Hello guys, this is Rishabh and you are watching Institute of Legal and Management Studies. ILMS Academy, India's premier legal and management education portal. Get certified to enhance employability. Today we will be learning about citizenship law in India. This lesson aims at discussing the citizenship law in India and overall implementation of the citizenship law while projecting light specifically on the 2019 amendment to the Act. The idea of citizenship represents the relationship between an individual and the state. Citizens, being the full members of the state, enjoy all civil, political, and economic rights provided by the states, including the fundamental rights, and only they are bound to adhere to the fundamental duties enshrined in the Constitution. Citizenship is the idea of exclusion of non-citizens from citizens of a state. At present, there are no two classes of people, one belonging to the citizen class and other belonging to the alien. Introduction. The citizenship law in India is based primarily on two principles on the basis of which citizenship is granted in India. Firstly, jus soli and secondly, jus sanguinis. Jus soli refers to citizenship on the basis of birth and jus sanguinis means citizenship on the basis of blood. The idea of jus sanguinis was rejected by the Indian Constituent Assembly as it was against the Indian culture and ethics. The Constitution of India provides citizenship to various categories of people and the same is enshrined under Article 511, that is, Part 2 of the Indian Constitution. The subject of citizenship is listed under the Union list and thus, the only right to legislate upon the laws of citizenship lies with the Parliament only, and any law made by the state on the subject shall be null and void. Article 5 of the Indian Constitution provides for citizenship on the commencement of the Indian Constitution. In furtherance of this article, those people who were born and domiciled in India were given citizenship. Citizenship was also extended to those people who were not born in India but either of whose parents were born in India. Citizenship on the commencement of Constitution was provided to people who were ordinary residents for more than 5 years in India. Also, Article 6 of the Indian Constitution provides for citizenship to persons who migrated to India from Pakistan. It provides that anyone who migrated to India before July 19, 1949 would automatically become an Indian citizen if either of his parents or grandparents were born in India. Those who entered India after this date need to register themselves. Article 7 of the Indian Constitution provides for rights of citizenship of certain migrants to Pakistan. It states that people who migrated to Pakistan after 1st March 1947 but returned on resettlement permits were included within the citizenship net and will be granted citizenship like those mentioned in Article 6 without registration. Further, Article 8 of the Indian Constitution deals with the rights of citizenship of certain persons of Indian origin residing outside India. Any person of Indian origin residing outside India or either of whose parents and grandparents who were born in India could register himself or herself as an Indian citizen with Indian diplomatic mission and on approval they'll be granted citizenship of India. Furthermore, Article 9 of the Indian Constitution states that any person who voluntarily acquires the citizenship of a foreign state will no longer be a citizen of India. Unlike the USA and some other countries, India does not follow the concept of dual citizenship. Any Indian citizen who acquired citizenship in a foreign country is no longer regarded as an Indian citizen. Thereafter, Article 10 of the Indian Constitution ensures that every person who is or is deemed to be a citizen of India under any of the foregoing provisions of this part shall, subject to provisions of any law that may be made by the Parliament, continue to be such a citizen unless declared otherwise. Lastly, Article 11 of the Indian Constitution provides that the Parliament is the sole authority with respect to the acquisition and termination of citizenship and all matters relating to it. It is the Parliament which makes the law on this subject, and that shall prevail, and all the states have to comply with this legislation. The Citizenship Act 1955. The constitutional provisions with regard to the citizenship are enshrined under Article 5 to 11 of the Indian Constitution. However, the legislative provisions and procedure for implementation by the executive is provided for under the Citizenship Act of 1955. It was the law enacted by the then Parliament and it dealt with the acquisition and determination of Indian citizenship. It provides for 4 kinds of citizenship, namely by birth, by descent, by naturalization, and lastly by registration. Number 1. Citizenship by birth. Every person born in India on or after 26 January 1950 but before 1st July 1987 is an Indian citizen irrespective of the nationality of his or her parents. Also, every person born in India between 1st July 1987 and 2nd December 2004 is a citizen of India given either of his or her parents is a citizen of the country at the time of his or her birth. Furthermore, every person born in India on or after 3rd December 2004 is a citizen of the country, given both his or her parents are Indian, or at least one parent is a citizen and the other is not an illegal immigrant at the time of the birth. Number 2. Citizenship by registration. A person of Indian origin who has been a resident of India for 7 years before applying for registration is eligible for citizenship through registration. Also, a person of Indian origin who is a resident of any other country outside undivided India and a person who is married to an Indian citizen and is an ordinary resident for 7 years before applying for registration are both eligible for citizenship through registration. Even minor children of persons who are citizens of India are regarded as citizens. Number 3. By descent. A person who is born outside India on or after 26 January 1950 is a citizen of India by descent if his or her father was a citizen of India by birth. A person born outside India on or after December 10, 1992 but before December 3, 2004 and if either of his or her parents were a citizen of India by birth shall be considered a citizen by descent. Also, if a person born outside India on or after 3rd December 2004 has to acquire citizenship, his or her parents have to declare that the minor does not hold a passport of any other country and his or her birth is registered at an Indian consulate within 1 year of birth. He or she shall be considered to be a citizen by descent. Number 4. Citizenship by naturalization. A person can acquire citizenship by naturalization if he or she is ordinarily resident of India for 12 years, throughout 12 months preceding the date of the application and 11 years in the aggregate, and fulfills all qualifications in the third schedule of the Citizenship Act. It is imperative to note that the aforementioned ways are the only modes to get Indian citizenship and no other means is allowed. Also, the Act does not provide for dual citizenship or dual nationality. It only allows citizenship for a person listed in the aforesaid provisions, that is, citizenship by birth, descent, registration, or naturalization. However, the Act was amended by the 2019 bill that was passed by the Parliament on 11 December 2019. Citizenship Amendment Act 2019. The Citizenship Amendment Act of 2019 seeks to amend the Citizenship Act of 1955. The Act of 1955 provided for citizenship in 4 ways, namely by birth, by naturalization, by registration, and by descent. This also includes the registration and rights of overseas citizens of India, OCIs. However, the 2019 Act seeks to amend the definition of an illegal immigrant for Hindu, Sikh, Parsi, Buddha, Jain and Christian immigrants from Pakistan, Afghanistan and Bangladesh who have lived in India without documentation and grant them Indian citizenship. This is in addition to the 4 ways mentioned earlier in the old Act. In September 2015 and July 2016, the government exempted certain groups of illegal immigrants from being imprisoned or deported. These are illegal immigrants who came into India from Afghanistan, Bangladesh or Pakistan on or before 31st December 2014 and belong to either of these religions, namely Hindu, Sikh, Buddhist, Jain, Parsi or Christian religious communities. The new amendment to the Citizenship Act provides citizenship to Hindus, Sikhs, Buddhists, Jains, Parsis and Christians if entered into India from Afghanistan, Bangladesh and Pakistan on or before 31st December 2014, and they will not be treated as illegal immigrants. Also, to avail this benefit, they also must have been exempted from the Foreigners Act 1946 and the Passport Act 1920 by the Central Government of India. The Act clarifies that these provisions of the 2019 Act on Citizenship for illegal immigrants will not apply to the tribal areas of Assam, Meghalaya, Mizoram and Tripura included in the 6th schedule of the Constitution. These tribal areas include Karbi, Anglong in Assam, Garo Hills in Meghalaya, Chamka district in Mizoram and Tripura tribal areas district. Furthermore, it will not apply to the inner line areas notified under the Bengal Eastern Frontier Regulation 1873. In these areas, visits by Indians are regulated through the inner line permit. Currently, this permit system is applicable to Arunachal Pradesh, Mizoram, and Nagaland. Manipur has also been brought under the inner line permit (ILP) regime through a gazette notification on the same day the bill was passed in the parliament. The Act also provides for cancellation of registration of OCIs. It states that the central government may cancel the registration of OCIs on certain grounds, including 1. If the OCI has registered through fraud. 2. If within 5 years of registration the OCI has been sentenced to imprisonment for 2 years or more. 3. If it becomes necessary in the interest of sovereignty and security of India. 4. An additional ground is also added by the Act for cancellation of registration. It declares that if the OCI has violated the provisions of the Act or of any other law as notified by the central government, his or her citizenship shall stand cancelled. However, the orders for cancellation of OCI should not be passed until the OCI cardholder is given an opportunity to be heard. Drawbacks of the new amendment. Since the enactment of the Act, there has been a lot of confusion with regard to the secularity of the amendment. It is said that the amendment contradicts the Assam Accord of 1985, which provided that illegal migrants, irrespective of any religion, entering from Bangladesh after 25th March 1971 would be deported. Critics also argue that updating NRC beyond the limit would make it null and void due to the new Amendment Act. It is also said that against the fundamental right to equality enshrined under Article 14 of the Indian Constitution, which protects citizens as well as foreigners, non-citizens. Most importantly, it is said to be in contravention to the basic fundamental principle of secularism enshrined under the preamble of the Indian Constitution. It is argued that India has several other refugees that includes Tamils from Sri Lanka and Hindu Rohingya from Myanmar, and yet they are not covered under the Amendment Act. Also, that it would be difficult for the government to differentiate between illegal migrants and those who are persecuted minorities in their country. In addition to this, the Act provides wide discretion to the government to cancel OCI registrations for both major offences like murder as well as minor offences like parking in a no parking zone or jumping a red light. However, the government has refuted all the aforementioned arguments that has contended in favor of the Act. It stated that the countries like Pakistan, Afghanistan and Bangladesh that are provided for under the new Act are Islamic countries where Muslims form majority, and the new Citizenship Act aims to provide citizenship to those people belonging to a persecuted minority in these countries. With regards to the questions pertaining to non-inclusion of minorities from Sri Lanka, Myanmar, etc., the government clarified that the process of awarding citizenship to refugees has been undertaken by different governments in the past on a case-to-case basis from time to time on reasonable qualifications to Article 14. This time the case of refugees fleeing religious persecution from these three countries have been considered through this Act. In January 2019, government had notified the High Level Committee HLC for implementation of Clause 6 of Assam Accord and urged the committee to submit its report at the earliest to the central government for effective steps to be taken to fulfill the provisions of the accord. The government thus has assured the people of Assam that their linguistic, cultural and social identity would be preserved and the provisions of the new Act do not tarnish the same. Conclusion. The petition challenging the enactment of the Amendment Act is still pending before the Supreme Court. It is now the prerogative of the Supreme Court to act as a protector of the Indian Constitution. The court is expected to read the provisions of the Act in light of the fundamental rights and the basic structure of the Constitution, and thereafter test the constitutionality of the Act and ensure that the classification suggested by the government on the ground of persecuted religious minorities is in line with the reasonable classification mentioned under Article 14 of the Indian Constitution. Visit ILMS Academy for various courses from contract drafting, RTI, labor law, GST and more. Get certified to enhance employability.